This is KTN News.
Welcome back. It is Judgment Day for the country as the Supreme Court is set to give a ruling on the presidential petition challenging the re-election of President Uhuru Kenyatta. In their determination, the judges of the Supreme Court will be guided by 5 key issues that were submitted by NASA's legal team, forming the backbone of the case challenging the re-election of President Uhuru Kenyatta. Top on the agenda of those key issues is the credibility of the Forms 34A and 34B used in announcing the final winner of the August 8th election. In studio with me, an able panel of lawyers helping us with this analysis: Dr. Alutalala Mukwana, Ashford Muriuki, and Ndegwa Njiru. Dr. Mukwana, just before we went on break, I was to get your thoughts on this first issue of the credibility of Form 34A and Form 34B, your analysis on how this issue was handled in the Supreme Court.
Thank you. Michelle, I would having been here for about a week, I would think that for purposes of transiting to what will happen today and possibly to the post-decision, we would concentrate more on the level where whatever the allegations were, evidence was tendered. So that, because if we go to whether the evidence was tendered or not, we sound repetitive.
Right.
Raila did tender his evidence. IBC did tender its defense. So did Chebukati, and so did Honorable Uhuru Kenyatta. I have maintained that I cannot discuss the merits and demerits of what was tendered on public television, because in my view, that would tend to tilt the public's view in a particular direction. We do not want to make the public to anticipate that NASA will win the case or that President Uhuru will win the case. I think at my level, I think that would be fair to expect from me. But having said that, we don't need to go into complexities. The claim by Raila is at the polling center, 34As were completed, they were transmitted to the Bomas of Kenya, and there was a problem right from the polling center to the tallying center. I am not so sure I would associate with my colleague's view that the decision by the appeal court in the KI case was wrong to say that the polling center is the final voting. I think if they did not say that, so where would you want the final place to be? Because Article 1 of the Constitution says that the sovereignty of the people is in the people, and that sovereignty is exercised by going to vote and voting. And where do they vote at? The polling center. At the polling center, once you vote in, it must be final. The rest you are transmitting, aren't you? I'll finish.
We'll give you a moment to get back to that. Go ahead, Dr.
So, in my view, that was correct decision. But now, what NASA is saying, and they have tendered evidence, whether it's the correct evidence, whether it's going to work, it's neither mine nor theirs. It's for the judges. These 34A forms, when NASA got the order to go and have access, they did get access. And a number of those forms were said, some were fake, which IBC actually owned up and said, yes, some could not have features. Others were photocopies, and others were not available. There's one, for example, which was produced at that time. I think it's from Northeastern, one of the constituents Northeastern. So it is not fair to say that, hey, this NASA, you claimed the forms were from 34As were not right, but now that you were shown. What were you shown? The forms that were shown had discrepancies. And so it is these discrepancies that we ought to now be dwelling on. Were the discrepancies going to be of such a magnitude as to affect the final product? You cannot talk of 34B and say, okay, even if 34A is not available, look, there is 34B. And the way Honorable Mwito was arguing, that nobody has argued about the numbers. I mean, this total is a product of the origin.
Right.
If the origin has a problem, don't tell us that this product is okay. So don't tell us that the baby is well and alive when the process of conception of the baby has had challenges. In my view, that would be very, very, very debatable.
Muriuki, you had to comment, something to comment on that.
Yes, please allow me to just correct this.
Please do. Thank you.
Now, my view, we need to, you had better understand what I'm trying to say here very clearly. What I'm saying, I have not actually saying that the Court of Appeal decision was entirely wrong. What I am saying is that the interpretation and the wording of that judgment, for those who took time to read it, to the effect that results as counted and tallied from the polling station at the constituency level by the returning officer and announced are final to the extent that the chairman of the IEBC or any other senior officer of the commission or even a commissioner cannot in any way alter those results. To that extent, that decision is wrong. Because the practical effect of it was to deprive the commission of any powers to either do verification of those results. For instance, when my friend here, Daktari, says, assuming you are right, that a particular Form 34B, Form 34A or 4B was fake or a forgery, yet it is transmitted to the National Tallying Center. What is the chair of IEBC supposed to do? What is the commission, as a commission, supposed to do? With that judgment from the Court of Appeal, as we sit here, their hands are tied. Now, to that extent, I do not agree with that judgment of the Court of Appeal. Now, let me just finish. And you will find, by the way, for those who took time, if you see from where we are coming from, if you read, like, for instance, the Independent Review Commission, Johan Klagra Commission, who did the independent review of the 2007-28 general election after the violence, they had actually warned against that practice where we used to have returning officers making decisions with regard to who has won, who has gotten how many votes at the polling stations or constituency level as final results. Because returning officers, my friend Daktari, these are temporary officers of IEBC.
All right.
The person who takes responsibility
I'll give you a moment, Diego, but let's...
is the commission or the commissioner. Because, let me just finish. How do you now complain in court, for instance, or at the National Tallying Center and tell the chairman of IBC or IBC that you did not verify these results? You did not, here I was given this number of votes, yet you have indicated this. You need to get into a situation where, before those results are actually announced, the commission, which is constitutional body, has got the right to verify, at least even if it's mathematical, or even if a form is fake, as you want to say. Who is going to determine that? It is not a returning officer who has been employed for a week.
May I say something?
Okay.
May I say something?
Before we give Dr. Mkwana right to respond.
May I say something, my colleagues here? The question is whether or not and what type of verdict we might want to expect today.
Precisely.
I believe we are past the Court of Appeal with its difficulties in implementations, how it has informed the process of the elections. I think that was well presented by the Attorney General when he was brought in as an amicus to bring in and feed into the jurisprudence of the Court of Appeal, how the jurisprudence of the Court of Appeal informs the election process. To me, today's judgment day will be determined on evidence and the law. And remember, world all over, even in our Kenyan jurisprudence, the courts have said that elections are conducted by human beings, and human beings are prone to apparent errors. If you look at Justice Maraga's judgment that he did for Joho in 2008, if you look at the judgments that Justice Lenora has handled, and the jurisprudence emerging from the High Court and the Court of Appeal regarding the elections and petitions, there is one commonality that all these courts are agreeing on, that you cannot, it's impossible to have an election devoid of human error. And when you say of Form 34, that Form 34 was not transmitted, this and this did not happen the right way, those are the failures that the courts are saying it's not possible to have an election that is devoid of human error unless we have robots doing and carrying out the process. So as we move on to the judgment day, the question then would be, how does that then jurisprudence inform today's decision? Secondly, how do our judges view and look at these cases depending on the question of the law, the question of the evidence and the past. And that's when I was coming to the question of the classifications of the judges insofar as the individual schools of thought belongs to. If you look at the previous judgments and the way Justice Maraga has dealt with the questions, he will tell you, how does this judge think? Where does he belong to? If you look at Justice Jokindungu, with the legislation of the sexual offences bill and the kind of the life she leads and the kind of the legislation she has done and the judgment she has been able to deliver, it will also tell you what kind of a judge she belongs to, and it's so true also for the others. So that is going to inform the process. If we have 4 positivist judges who think that the law must be followed as it is, that yes, there were 8.2 million votes, he won, there were 6.7 million votes, he lost. But what was the process? Was the process followed to the letter? Were there transgressions of the law? If we have the majority of the judges thinking that the law must be followed as it is and as it is written, then you can know how the Supreme Court will vote.
All right. Let me get Dr. Mkona's final word on this before we move on.
Kakangu Ndwiga umesema, umegonga ndipo. Kila binadamu ana makosa. Lakini hayo makosa yalikithiri kiwango gani katika uchaguzi? That is the point, Michelle. And that is what you've been saying all along. That what Honorable Raila has claimed, IEBC has not denied 100%. It has said yes, but it has summed them as errors. That's the long and short of it. So it is now up to the judges to say, are these errors premeditated in the first place? Because then you ask, if there can be so many errors, were they accidental?
Right.
Are they premeditated? And you could see it on the face of the charges. You remember how the DCJ, Philomena Mwilu, asked Counsel Musheru when he was trying to explain the concept of stray ballots. And he said, you see, when you enter into the booth, you have 6. You put 1 for the presidential and this other one, and he was unable to explain. Honorable Smokin Wanjala intervened, and poor colleague was still unable to explain. So those are pointers that indeed these errors, which my colleague is actually owning up, that human is to error, there were errors. But these are the errors that the NASA people are saying, my lords, these are not ordinary errors. These are errors that were premeditated. These were errors that fatally wound the election process. These are errors that go against the provisional constitution. The provisions of the constitution say results must be free, verifiable, accountable per Article 83, 84, 86 as you go down on the Constitution. So in my view, what we should be talking about here is not whether NASA approved or not. In my view, let's leave it to the judges. But if, Michelle, if you went to the social media where it is always bare knuckles, forget what we do here. On mainstream media, we are gentle. We only talk what we think should be right. Some of us come here from different backgrounds, and we do not know why we're here, you know, with due respect to all of us. So here, we sugarcoat what you say. But go to the social media. It's bare knuckle. These so-called errors, if you hear what people are saying on social media, both sides of Uhuru, it's bare knuckle. And my colleagues here will say. That's why I'm saying, as an advocate of the High Court Kenya, I would rather not discuss on the merits of the evidence, because it will amount to pointing to saying Raila's case is dead on arrival. Or saying Uhuru's win must be invalidated.
Right.
That's not for us. Finally, my brother here is opening a Pandora's box, literally. You know,
Toxic one.
sorry?
Very toxic.
But precisely, he's opening a Pandora's box. You cannot say that the decision that was made in the Court of Appeal tied the hands of the Electoral Commission.
Precisely.
Such that the results that come from Murarandia polling station is the Kahuno polling station. When they arrive at Chebukati's hands, his hands are tied, and all he has to transfer what is in 34B to 34C and declare the president. That is a fallacy. Number one, 34C that Chebukati signed, it was shown, was also not proper. It did not have the security features. So does that appeal decision tell him you should not even look at the form you're signing? Number two,
And the law required for collation of results.
Thank you. Number two, assuming that what my brother is saying is true, that Chebukati's hands were tied, did the Court of Appeal decision say, even if you realize that the results as brought are not adding up, that the forms, some are not signed, that some of the forms are photocopies which don't have the same security features of the forms you printed by Al Ghurair in Dubai, should the loser go to court, you must also vigorously defend those forms, which are utterly defective. That would be a fallacy. He should have said, when Chebukati went to court, therefore, and he realized that this happened, he owned up and actually assisted the court, because Chebukati is a lawyer. And we lawyers have a responsibility as officers of the court to help the court to arriving a just and expeditious decision.
All right.
So he could have said, okay, my lord, I signed, but with the benefit of hindsight, I think we could have done better. That is the impartiality, the fairness, the verifiability that we are talking about.
All right. I want to look at one more piece of, one more issue that Raila Odinga had put forward before we get into the options or the different scenarios that the Supreme Court will be looking at. That is issue number 4. Raila claims that IBC used ungazetted polling stations and ungazetted returning officers during the elections. Something, again, throwing a lot of doubt into the credibility and the integrity of this process. IBC's defense that there were no polling stations or officers that were not gazetted. Let's come back to you, Ndegwa, in terms of the doubt that this issue brought up by NASA would bring.
May I say that if there is something that the two functions, NASA and Jubilee, and actually the three and Chebukati, if there is one thing that NASA was able to bring out during the hearing of the case, is that when you are analyzing the elections, not just presidential, but even other elections, you do not just look at the question or the numbers alone. You don't stop there. NASA was able to go further and also say, let's also audit the process. Remember, it's the first time the court is going to make a determination as to whether or not, when you're looking at the winner, you also have to look at the way the process was followed. It's the first time in the history of Kenya. So, and where are we coming from? We are coming from the constitutional provision that the court has jurisdiction to investigate whether or not anything done or said to be done under the Constitution was done in accordance with the Constitution. So if there is anything NASA has succeeded, is to cast aspersions and doubts as to the process.
Indeed, indeed.
And the judges must then give us a return and a verdict whether or not we only need to deal with who had the majority of the numbers, or we also have to investigate how were those numbers yielded. Remember, an election has an infrastructure, and the infrastructure of an election is a legal, laid down legal procedures. If they were faulted, the court must answer us whether those faults affect the results. And if they affect the results, whether then the court can invalidate those results because of the transgressions in the law. Yes.
All right. Muriuki.
Now, Michelle, I think at the risk of boring you or boring our viewers or listeners, let me just repeat once again. The issue of there having been either non-gazetted polling stations or
non-gazetted returning officers
is just another one of the very many allegations which was made by the petitioner. As we sit here, we do not know whether proved or not proved. But I think Honorable Raila and his team presented their evidence. And I think, to the best of my recollection, IBC and the respondent also gave their response and explanations as to why. And I think they said, actually, there was no, that is not true, to be very brief, that it's not true. They had gazetted, they had done some supplementary Kenya Gazette notices and all that. But the question that you really need to ask yourself is, you can have all these grievances, but the question is, what ultimately turns on what? You know, even assuming that let's say, even assuming that some of these allegations are true, as a lawyer, you need to ask yourself, then what? What are the consequences? Like my friend here is saying, there's a big issue as we sit here as to whether you have to show, because we have an elections law that says that even if there are those violations of the elections law, unless they substantially affect the result or the ultimate outcome of the election, then you cannot invalidate an election. Now, that is still a very controversial provision in the law. So we need to ask ourselves, what is the threshold? Because we must agree, Michelle, as long as we are human beings on this, living on this planet, as long as it's an electoral contest or any other contest, there will be a winner and a loser. And losing an election is very bitter. Yeah, it is very bitter, it is emotional, it is expensive and all that. So there has to be grievances. The question that the law addresses is it that just because you have grievance A, B, C, that you have to nullify an election? No. There is a threshold. There are procedures which you must be, any party must follow. There has to be a certain evidential value. And there has to be some basic principles that must be followed.
All right.
Before you can overturn an election. The mere fact that you have 1,000,001 complaints about an election is not automatic.
It does not matter. All right, so let's hear from Dr. Mukwana. We don't have much time. Let's hear from Dr. Mukwana on this
Thank you. My brother is very interesting. Basically, he's repeating what we have already said. Let's move from there. The easiest way to help ourselves here and to help your viewers, Michelle, is to ask. NASA claims that they were ungazetted polling centers. What is Chebukati's answer and IBC's answer? They are saying that is not true. That is a denial. But they ought to go further and tell us, actually, to prove that there were no ungazetted polling centers, this is what happened. What has NASA done to prove that? I'm not saying they have proved because it's up to the judges. NASA has said this. How do we know that there were ungazetted polling centers? Go to the server, get the GPS location of the polling center.
Which they did not get.
Which they did not give. IBC did not give that. If they had given the GPS location of all the polling centers, then we'll say, yes, all the results came from the only gazetted polling center. Number two, NASA asked, and the court granted, because the court saw the merit in that request. NASA asked for the GPRS location, exact GPRS location, for the KIMS kits. Because remember, not all KIMS kits that were bought were used. And NASA is claiming that some of the votes came from kits that one cannot be traced which polling station they came from. And again, IBC did not give the GPRS location of all the kits. It is on record by the registrar's report in court. So, beyond that, you don't need to be a lawyer to suspect that those kind of events could not be errors. Yes, there could have been errors on the 8th and on the 9th. There can't have been errors on the day when the court made an order that now let the complainant, the petitioner, access this.
Well, as it is, Dr. Mukwana, the service providers were sleeping
and
in Europe. But let's focus on what is more important, and that is what decision the Supreme Court will have today. There's only two decisions, to either validate the decision of the IBC's announcement or invalidate it. What, in your view, Ndegwa, would either outcome mean for the country?
May I say that during the hearing of this case, it was President Uhuru Kenyatta and Prime Minister retired Raila Odinga. The advocates for Raila Odinga were representing Raila Odinga and his supporters. The advocates for Uhuru Kenyatta were representing Uhuru Kenyatta and his supporters. It's only one person who was there, or who is there for the Kenyans, and that is the court. So we are not looking at the 8 million, we are not looking at the 6 million, we are looking at the 45 million Kenyans. And now, it is in the best interest of the court to safeguard the interest of not the voters who supported the individual presidential candidates, but even that person who did not vote, like my son, who is 3 years old. So the court is under an obligation and a duty to make sure that whatever verdict they give meets the interest of the Kenyans and sustains the sovereignty of the people of Kenya. if the verdict is in any way going to alter the validity and to affect the sovereignty of the people of Kenya, then the court must tread very warily. Finally, I see that these courts have been established by the people of Kenya. In matter of fact, if you look at Article 159, it says that judicial power is derived from the people. So this power has been derived from NASA supporters, from Jubilee supporters, and from those people who are apolitical. So essentially, we must be ready, able, and willing to accept the verdict of the court as it may come. This is not a win either for Jubilee. It should not be looked at a contest between Jubilee and NASA, because now we are dealing with the question of Kenyans, the sovereignty of Kenyans being sustained. So I urge the people of Kenya to be ready and accommodative to accept the judgment as it may come. Remember, these judges are neither Jubilee judges or they are neither NASA judges. These are Kenyans. They belong to that class of their political persons, like those people who never even voted. That's how we should view the court as being impartial. Let us not cast any aspersion that might cast doubts as to the outcome of the court. Because at the end of the day, we said past 8th of August, Kenya will still be there, and yes, we are. So even past today, we must make sure that we have and retain the country known as the Republic of Kenya.
All right. Dr. Mukwana, let's hear from you and the impact the decision of the Supreme Court will have, because it is either to invalidate or validate, and one will lead to a re-election and one will lead to business as usual as the president appoints his cabinet. Your thoughts on how this is going to impact the country?
Yes, Michelle, I wish to associate myself with my learned colleagues' views that Kenya will be there after this. Having said that, I think in what the Supreme Court judges ought to do is to be guided, and only guided, by the evidence before them and by their loyalty to this country. In the social media, and again, if you allow me, without necessarily using that as my source of authority, Kenyans are at it, bare-knuckled. And the kind of epithets and obscenities they are shouting across makes me shudder at the realization that whichever way this verdict is going to go, Kenya will remain very divided. And therefore, the Supreme Court must be guided by nothing but the evidence and their loyalty to this country. It is only them who can placate Raila supporters, and it is only them who can placate Uhuru supporters.
Correct.
And that they will not do by sweeping everything under the carpet. This morning, you interested me when you illustrated that cartoon.
Yes, that was in the Standard newspaper.
Yes, the red carpet and all 34 A's are there. Everything is there being swept under the carpet. I didn't see the child who's born well and alive. Was she also swept under the carpet? So, the judges must be guided by that. They're the only ones, and I dare repeat, this country will only be saved by the decision of the judges, whichever way it goes. If the decision comes in a way that the Raila supporters feel that they have been handled, everything has been addressed. Not necessarily that they have to win, but everything has been addressed and a response and a justification given, Kenya will move forward. Right. It can never move forward if things will be swept under the carpet. And remember, before you close, that let's not cheat ourselves that Kenyans will only obey the courts. We must understand that the decisions of the court can have impact politically. After all, you must remember, this 2010 constitution was not brought by obedience to the law. It was brought actually because Kenyans went to the street and died.
Let me say, allow me to have a rejoinder on what I can say.
Let's just give Muriki's closing comments first, because we are out of time.
Michelle, I will say this. Let us have confidence in our courts. Let us have confidence in the Supreme Court. Now, let us not intimidate the court and the judges. Let us not put the judges on toes. You know, the judges don't have to please anybody. They just have to do their job. They don't have to please Raila supporters. They don't have to please Uhuru Kenyatta supporters.
True, true.
Our judges just need to be one, brave, brilliant, and to do their job without fear or favor. As my friend here says, Daktari, that they know the law. Let them stick to the law.
Right.
Evidence was presented. Let them stick to that evidence.
All right, so we'll be waiting.
So it's not a question of like, oh, this country is going, nothing is going to happen. We just need to believe in our institutions as long as our good judges do to their best of ability without fear or favor and render a decision, whichever way. And then from then on,
we'll see what comes next.
Just
very briefly.
One reminder very briefly that I want to urge Kenyans not just to listen to what Daktari is saying, that even the constitutional revolution that we have was not brought by the obedience of the law. It actually was yielded by the disobedience of the same. But now since we have a constitution...
What is factual on that one?
The factual is, yes, it is true, the constitution was yielded through civil disobedience. But now, since we have the constitution that has laid down the infrastructures and the institutions, then we can only pay allegiance to it, noting that the country must remain as a republic and a sovereign republic of Kenya.
That is not in dispute.
We have much to suffer if we breach the constitution and abrogate it. Next time, and people must be ready to accept the verdict of the court as it is. Remember, even Uhuru Kenyatta has supporters. If the election is invalidated, they have a reason to question it. Raila Odinga has supporters. If the election is, if the petition is dismissed, they have a right to question it. But the question is, shall it just be a contest between Raila Odinga and Uhuru Kenyatta, or shall it be the question of the Kenyan people?
All right.
Michelle,
well,
if you close on that,
gentlemen, we'll really have to close now.
Just want to say, I said and I repeat that the judiciary, only the judiciary can save the country. They can placate both sides. Beyond today, we are one people, one country. We must remain so.
All right, so that is a good point to close this conversation. Dr. Alutalala Mukwana, Ashford Muriuki, and Ndegwa Njiru, lawyers helping us here on the early morning edition of Kivumbi 2017 on a pre-analysis of that decision the Supreme Court will be giving in the course of the day with regard to the presidential petition lodged by Raila Odinga challenging the re-election of President Uhuru Kenyatta. Do stay tuned to KTN News for unrivaled coverage of those Supreme Court proceedings. It is now 10 minutes past the hour. We'll take a short commercial break here on Kivumbi 2017. Do stay with us. When we come back, we'll take a look at top stories making headlines in the country and beyond.